You answered it, but now...
Thank you, Prof.
I'll now request Honorable Commissioner Mohammed Wasame Judge to continue the technical questions.
Thank you, Professor. Senior Counsel, from what you have stated, you are a successful advocate and you have practiced law for quite some time. I want to know and understand what motivated you to apply for the position of CJ and what you are looking for and what values, both in terms of administrative leader, jurisprudential leader, you bring on board.
Thank you, my Lord. Chief Justice before 2010, I would not have been interested. Chief Justice after 2010, I'll be interested. Interested to serve. I emphasize interested to serve for the following reasons. Post 2010, the Chief Justice is really a leader and a transformative leader. A leader who will never take us back to the state of nature that we almost experienced in 2008. A leader to take this country to a level that we can now compete with our equals in the world. What values do I bring? My Lord, I bring the following values. Ethics is one of my core attributes. I'll bring ethical values into this judiciary. Ethics not in terms of saying do and don't, but to inculcate a culture that we know we are there to serve. To inculcate a culture of correct work ethic. Correct work ethic is not something you legislate. It's something you almost, so to speak, fellowship with the fellow judges. And we agree that really let us be servants of the people who have given us this power. This judicial power is derived to us or given to us by the people of Kenya. We are trustees. Let us not abuse that trust. I'll bring all those values. I'll bring the values of hard work. Allow me to say this, my Lord. In this career that you have referred to as successful, it is a career that I have managed because of one word, perseverance. And for any lawyers, wherever they may be, young lawyers particularly, I would want to tell them this. This legal career, if one is starting, you do it brick by brick. There are no instant successes. And equally for the judiciary, I would wish to have discussions with judges at JTI and to see that really by peer review we can even improve our reasoning in judgments and rulings. Those are some of the values that I believe I'll bring.
Thank you very much.
I'll bring that value of continuous reading of beyond law, philosophy, and other disciplines. Thank you, my Lord.
You have also talked about the impressive CV of Mutunga and Maraga, what they did as Chief Justice. Because of the 2010 Constitution, having served also in the judiciary even before them, I was also very impressed with Evans Gisheru as Chief Justice. That's for your information. JSC is looking for a Chief Justice who can take the judiciary to the next generation. After Mutunga, after Maraga. I want you to share with the Commission, from your experience and knowledge, 3 institutional weaknesses, if any, in the judiciary that you will address so that you can take the judiciary to the next level. 3 institutional weaknesses.
Before I go to the 3, my Lord, Chief Justice Gisheru and other Chief Justices also did beautiful work. I was here when Chief Justice Madan was the Chief Justice Coker. I have worked under them. They did wonderful work under difficult circumstances. But those circumstances are no longer with us. The structural difficulties which were there are no longer there. Some of the, and I say this not as a condemnation, we still have weaknesses in delivery of or conclusion of cases. Conclusion of cases is still bedeviling us in a very major way. Hearing of cases is also something that is still a challenge. ICT, as my Lord is aware, we have done, and I must say this, it is my heart to judiciary, we have overcome the mental barrier. Most of us had a mental barrier that ICT cannot work. We have overcome that barrier. We now know ICT can work. All we need to do is add capacity, and we are almost there. And with ICT, with other human skills, human resources, will be more or less on the way to the next level.
Thank you very much. Now let's go to the difficult issue. This is RILA 2013, which in my view spearheaded a critical legislative reform in the election laws that included the incorporation of technology in our elections. But one of the critics of that decision is what the court called the timely filings of election petitions. And you were involved in this case. The court rejected that voluminous affidavit by the petitioner, which was filed, in my view, within which was not filed within the it was not filed with the petition, but it was filed before the determination or the hearing of the petition. Are you a Chief Justice who will give broader interpretation to filing of petitions, such that if somebody feels he has filed the petition within the 7 days, but there are critical issues which needs to be brought before the court, and is brought before the determination of the decision, are you a Chief Justice who will allow broader determination, broader interpretation, such that justice is served to all litigants who come before the Supreme Court, especially in presidential petitions?
My Lord, as you indicated, is a difficult question, but we can actually answer this on principles of the Constitution. The first principle, my Lord, is that we have 14 days for Supreme Court to decide. Or let's start a little earlier. From the declaration of the result, an aggrieved party has 7 days, 7 solid days. Put your act together. So the petitioner has a very big advantage, and I would want to be understood in this very well. Petitioner has 7 days from declaration of result. A petitioner who is desirous or who considers that if all doesn't work well, I'll be petitioning Supreme Court, has another almost 5 days at Bomas of Kenya, where collation of results is taking place. So cumulatively, a petitioner who is diligent has 12 days to put his house together. The respondent has a very short period to answer hundreds and hundreds of volumes of pages. And my Lord, as you indicated, I've had the advantage, or I've had the privilege of handling this. It is not once or twice. I had, together with my legal team, less than 2 hours of sleep per day, because you are dealing with massive accusations, massive innuendos, and massive everything. So the respondent actually is disadvantaged. By the time of filing this, you have Supreme Court, per the Constitution, has 14 days. My Lord, let's agree that is cast in stone. It's not elastic. If you are to allow the same petitioner who had 12 days to put his act together to be able to come with another affidavit that would require me another 3 or 4 days to respond, my Lord, you take us to Zambia. We go directly to Zambia, where the judges realized on the 14th day that our time is up and we have not had these characters. It's a dangerous thing. So, my Lord, it's not even being broader interpretation. It is simply this. Unless there is any amendment, the 14 days is the day the Supreme Court must hear and determine. So you cannot have the luxury of allowing one party more latitude than the other. Allow me to say this, my Lord. If further affidavit was allowed, principles of natural justice, I would have been given corresponding time to respond. If I'm given corresponding time to respond of the 14 days, then we'll start a hearing on the 11th or 12th or 14th day. It's not possible for a hearing to be done.
Okay. Another critique leveled at the court in 2013, the Raila case, is that the court is allowed within 14 days to hear and determine the election petition. But on the 14th day or on the 13th day, the court renders one paragraph judgment. In essence, people are saying, and the decision is rendered maybe after 1 month or 2 months, the court is enlarging the constitutional timelines by not rendering the full and the final judgment of the court. Are you a Chief Justice who will ensure judges of the Supreme Court render their judgment on the 14th day or on the 13th day as provided for under the Constitution?
Yes, my Lord. And this depends really from, now I speak as a practitioner, different styles by judges. I've been before quite a few of your brothers and sisters, particularly of yesteryear, who at the conclusion of the case will come up with a decision of the case and say reasons to be provided later. I've had that experience. And I would agree with you, the problem with that is this. I do not know for certainty why the decision went the way it is. I think the middle ground is this. I'll borrow heavily from Warren. You do not need a Ph.D. or a master's as a judgment in any case. In Warren, in the Brown case, it was a 12-page, and it was sufficiently well-reasoned to be a judgment. If given the opportunity, as a Chief Justice, I would endeavor to my utmost to have a reasoned judgment within the 14 days.
Again, let's come to Raila 2017, Raila 1 2017. The petition was invalidated on the interpretation of Section 83. And the court accorded the section a disjunctive interpretation. Given the use of the word or, and later after the decision there was an attempt by Parliament to replace the word or with under, which was rejected, as you correctly said, by the Court of Appeal through an application made by Katiba. As a Chief Justice, are you a Chief Justice who, because the Supreme Court is allowed through majority decision to depart from its earlier decision, are you a Chief Justice who will depart from that position because your position that time was the conjunctive interpretation should be given to Section 83? I know it's a difficult, but you have the liberty to answer.
My Lord, you place me in an awkward situation where, probability, the emerging political formations are listening to this, I'll approach that court with a very open mind. Neither conjunctive nor disjunctive. I'll listen to them, oblivious of what my arguments there before were. And there's a lot to be said about this. The minute I take my judicial office, my oath of office, it becomes a divorce, the cut of the umbilical cord, between Ngatia, practitioner, and Ngatia, Chief Justice. It is a dicey issue, or has been argued, and I have argued, or can mean as an and it has been argued to the contrary. I'll be a Chief Justice who listens to legal arguments, oblivious of what I may have argued before, and rule in accordance with the Constitution.
Okay, let's come to the simple issues. In your first annual address, the Soja address to the people of Kenya, tell us 3 messages you will convey to the people of Kenya in major areas that you feel the judiciary is lacking or is of concern to you.
I will not approach the people of Kenya with an alarmist statement that the judiciary is lacking anything. My first statement will be that you have a judiciary that is capable and has been delivering very good service. I will be actually a Chief Justice who will tell the people of Kenya, we are here to serve you. But I'll go further and indicate areas that we shall progressively work with them and make this judiciary even more profound in their day-to-day activities. I'll tell them the days of paying cash at the registry are days gone. We do not want so much interface with people. And I'll tell them in 2011, the revenue that we collected is 500 million. Last year, I think it was 2.8 billion. So I'll tell them, let's have more faith in technology. It's much easier for you to pay through an M-Pesa. I'll also tell them that there's this perceived rot in the judiciary, your file is missing. We are going to work together to have a digital filing system, the e-filing system. And I'll tell them that very soon we'll try to have even courthouses to be able to do e-filing for litigants in person. And I will explain to them the beauty with e-filing is that from the comfort of your phone, you can see how your case is progressing. In other words, my Lord, I'll be not a Chief Justice to condemn judiciary. I'll be a Chief Justice to show Kenyans that we are here as their servants and we are going to take the judiciary to the same level, if not higher, than what Singapore has achieved.
Thank you. And lastly, Senior Counsel, your solution for the 41 judges. And I wish you well.
My Lord, 41 judges, they are now 40 out of attrition. There are many solutions to it. The solution of a discussion would be the best. Failing a discussion, I would do my very, very level best. But my message would be this. I need all hands on deck. Without hands on deck, I will not be able to achieve. So the approach would be, let us find a solution. Let's not deal so much with the legalistic positions, much as they may end up with the result or the other. I would say, I need hands on deck. I am a captain, I'm handicapped, and there are difficult winds ahead, difficult storms ahead. I need all hands on deck.
Thank you, Prof.
Thank you very much, Judge Wasame. Thank you, Senior Counsel. It's now the turn of Honorable Judge Majaja, Commissioner, to continue with the questioning.
Thank you, Chair, and welcome, Senior Counsel.